Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our content, please remember to hit the notification bell so that you can get alerts of all of our live stream and other uploaded content. For this morning's live stream, we are doing a decision that I missed because it was done in a summary way by the United States Supreme Court, which is kind of hilarious, and also deals with the issue of qualified immunity, a topic that we have discussed on this channel many times with great skepticism. And the United States Supreme Court beats the Eighth Circuit to death because they've dealt with qualified immunity in such a summary way that they feel like due process has not been fully adequately dealt with. How fun. So we're going to read this summary decision from the United States Supreme Court. What do I mean by summary decision? Well, what I mean is that the Supreme Court granted and decided the issue on the papers. There was an oral argument. They took the papers in and they're like, yep, they screwed that up. So we're just gonna rule. That's a thing that happens sometimes, not very often, but it did. So we're going to read about this in the case of Jody Lombardo versus the city of St. Louis in the great state of Missouri. Let's learn a little bit about what happened in this case, and a little bit about how the Eighth Circuit treated it so shortly. The Supreme Court's like, no, maybe actually you should, look at the facts. That might be a good idea. You should look at the facts. So let's look at the facts. How about that? That sounds like fun. Something the Eighth Circuit didn't do. Great. Per curam, which means that it has no listed author, because the Supreme Court is just going to do this in a summary way. So we are collectively going to beat the Eighth Circuit to death. How nice. On the afternoon of December the 8th of 2015, the St. Louis police officers arrested Nicholas Gilbert for trespassing in a condemned building and failing to appear in court for a traffic ticket. These seem like relatively minor offenses, all things considered. He is trespassing in a condemned building. An urban explorer, perhaps. And arrested, which might itself be a touch excessive depending, but let's read on. Officers brought him to the St. Louis Metropolitan Police Department Central Station and placed him in a holding cell. At some point, an officer saw Gilbert tie a piece of clothing around the bars of his cell and put it around his neck in an apparent attempt to cause self-harm. So things have escalated dramatically over here in St. Louis. Our urban explorer friend has been captured on some fairly minor violations. A little bit of urban exploring and some kind of failure to appear in court for a traffic ticket, which is absolutely something they will arrest you for, right? The failure to appear. We're not arresting you for the traffic ticket. We're arresting you because you failed to appear to court, to summons. When the court says you are summoned, they mean it. And if you don't show up, they'll arrest you. So they've arrested him, and our friend over here has decided to respond to this. All things in the great, somewhat minor. It's not like we shouldn't take court seriously with their summons, but, in the grand scheme, fairly minor violations, particularly when we take into consideration his response, which is apparently I'm going to take off pieces of my clothing, tie it around the bars, and put it around my own neck. This is discouraging. So we probably should do something about that. How and what we're going to do, though, is going to be the problem. 3 officers responded and entered the cell. Well, at least they were paying attention. That's more than we can say sometimes, right? One officer grabbed Gilbert's wrist and handcuffed him, but Gilbert evaded the officer and began to struggle. 3 officers brought Gilbert, who was 5'3" and 160 pounds, short guy, short king, down to a kneeling position over a concrete bench in the cell and handcuffed his arms behind his back. All right, so at this point, he is on his knees and he's also handcuffed behind his back. All right, that's an important detail. Gilbert reared back, kicked the officers, and hit his head on the bench. Gilbert's not having it, man. After Gilbert kicked one of the officers in the groin, They continued to call for more help and leg shackles. While Gilbert continued the struggle, 2 officers shackled his legs together. So now he's handcuffed behind his back and he's shackled. Emergency medical services were phoned for assistance. Several more officers responded. They relieved 2 of the original 3 officers, leaving 6 officers in the cell with Gilbert, who is now handcuffed and in leg irons, okay? So we are pressing all this forward, right, to show the sequence of events, because facts matter. Whether they're blue facts or not, right? Whether they're blue facts or not. Facts matter. That was a bad joke. I'm sorry. Anyways, but yes, the facts matter. And in this particular facts, right, he's handcuffed behind his back. He's in leg irons. What happened next? Let's read more. 3 officers held Gilbert's limb down at the shoulders, leg, biceps, and legs. At least 1 other placed pressure on his back and torso. He's already in handcuffs and leg irons at this point. Gilbert tries to raise his chest, saying, "It hurts. Stop." After 15 minutes of struggling in this position, Gilbert's breathing becomes abnormal and he stops moving. Uh-oh. Okay. So this fact pattern is sounding vaguely familiar to recent events, right? We have a suspect who initially was non-compliant and has been rendered into a position of diminished ability by the handcuffs behind the back and by the leg irons. And now we've got 3 officers holding him down at his biceps and legs and shoulders. And this went on for 15 minutes, which is resulting in problems breathing. This sounds vaguely familiar. Let's read some more. The officers rolled Gilbert onto his side and then back to check for a pulse. Finding none, they performed chest compressions and rescue breathing. An ambulance eventually transported Gilbert to the hospital, where he was pronounced dead. So this fairly minor episode has resulted in a person's death. We found this guy urban exploring, and perhaps more importantly, in defiance of a court ticket. So if they weren't going to arrest him for the urban exploring, they're going to arrest him for the not showing up to a court. When the court says you are summoned, it's not an option. You are summoned. So he didn't do that, and now he's under arrest. And he is acting in very aggressive ways. One might wonder whether or not he's on something. In any case, he was handcuffed behind his back. He's put in long leg irons, and now we've got 3 different officers at different parts on him for 15 minutes, which caused him to stop breathing, and now he's dead. Okay. Gilbert's parents sued, alleging the officers used excessive force. The district court granted summary judgment in favor of the officers, concluding they were entitled to qualified immunity because they did not violate a constitutional right that was clearly established at the time of the incident. The U.S. Court of Appeals for 8th Circuit affirmed on different grounds, holding the officers did not apply unconstitutionally excessive force. Okay, so we've got some analysis of some facts and some law, and now the U.S. Supreme Court would like to appropriately chide the court for not looking at it with enough degree of resolution. In assessing the claim of excessive force, courts asked whether the officer's actions are objectively reasonable in light and circumstances confronting them, citing Graham v. Connor, which, depending on your level of interest in recent events in the news, might be a case you've heard about recently, perhaps to the point that you're sick of hearing about it. Graham v. Connor, you may have heard of this before. A court cannot apply the standard mechanistically or mechanically. Rather, the inquiry requires careful attention to facts and circumstances. Facts. Those circumstances include the relationship between the need of use of force and the amount of force used, the extent of the injury, any effort made by the officer to temper or limit the amount of force, the severity of this problem at issue, the threat reasonably perceived, and whether the plaintiff was actively resisting. These factors may or may not ring with some degree of familiarity in your mind. You may or may not have heard about these factors a lot in somewhat laborious detail recently. Graham v. Connor. Any of this ringing any bells to anybody? Yeah. Although the Eighth Circuit cited these factors, it is unclear whether the court thought the use of a prone restraint, no matter kind, intensity, duration, or circumstances, is per se constitutional, as long as an individual appears to resist officers' efforts to subdue him. The court cited the circuit precedent for the proposition that, quote, the use of prone restraint is not objectively unreasonable when a detainee actively resists officers' directives and efforts to subdue. The court went on to describe as insignificant facts, and this is the problem, right? You got to look at all the facts. And when the court uses a word like insignificant, that can be a problem. The court went on to describe insignificant facts that may distinguish that precedent and apparently, potentially, importantly, under the relevant law, include whether Gilbert was already handcuffed and leg shackled when the officers moved him in the prone position and kept on him for 15 minutes. That strikes me as not necessarily an inconsequential or unimportant fact. I certainly recognize that not all facts matter equally, and some facts can be safely ignored. But when you're trying to decide whether or not the officers can put weight on someone in the prone position, right, as a matter of constitutional law, facts matter. They matter. What is happening? What exactly is occurring? All the facts are relevant. Is the suspect resistant? If he's initially resistant, did he become compliant? Is he now surrendering? What restraints have you used? How does that change the analysis? And so forth and so on. We got to look at the whole picture, right? In sort of assessing this along a gradient. And the Eighth Circuit over here says, the case law says that you can put someone in the prone position and it's okay. And here's a totally unimportant fact. He was already in handcuffs and leg irons at the time. I don't know. In trying to determine what amount of force is reasonable and what amount of force is constitutionally excessive, that fact strikes me as potentially relevant. And there are other facts that are potentially relevant here, like the fact that he was kicking the officers in the groin. Was he doing it for all 15 minutes? What is the full nature of this timeline? What is the full nature of his compliance or lack thereof as we are assessing the continuing use of this level of force? And the Eighth Circuit Court of Appeals apparently just says, oh, it's totally cool because the prone position is totally cool. And the Supreme Court's like, not necessarily. The prone position may be okay, but maybe some more facts. Such details could matter. Blue flags matter. When deciding whether to grant summary judgment on the excessive force claim. Yeah. Here, for example, the evidence, viewed in light most favorable to Gilbert and his parents who are suing, shows the officers placed pressure on his back, even though St. Louis instructs its officers that pressing down on the prone position can cause suffocation. This goes to experience and training. And it also goes to the standard protocols that are used for this and how a reasonable officer would behave in the circumstances. You know what would inform the way a reasonable officer would act? The training. All the training. Is this action authorized? If so, using what procedures? In what way is it authorized? Does the training and experience speak to maybe it stops becoming authorized at some point? Maybe at some point you were supposed to do something else and completely failed to do that? Or maybe you didn't undergo it in the right way. Maybe you put your full body weight on them, for example. Or maybe you put your weight on a part of the body in a way that is not authorized, or you did it in an ongoing way even though the situation didn't require that. Maybe you need to look at this in a more complete factual picture. And the training materials which says, hey, here is how to do it, here's how not to do it, here's when to stop doing it. Kind of important in the analysis, don't you think? Eighth Circuit Court of Appeals. The evidentiary record also includes a well-known police guidance recommending officers get a subject off his stomach as soon as handcuffed because of risk. Well, geez, that sounds familiar. When you're in the prone position and already handcuffed, that sounds familiar. The guidance further indicates the struggle of a prone suspect may be due to oxygen deficiency rather than a desire to disobey commands, right? So the reason for non-compliance may not be defiance. It may be literal inability to comply, which is a material factual consideration that has to be assessed as we're determining the reasonableness of this, which again needs to be considered in the full factual picture. You can't just look at part of it. You can't just say, oh, this procedure is authorized sometimes. You can't just say, oh, the training material says this is an authorized procedure sometimes and using some methods. And therefore say, oh, it's authorized at all times and all methods. And the officer did it so badly and in such defiance that it became radically inappropriate based on the manual and based on the instructions. Things like you should be worried about a person who is prone, which is another way of saying on their stomach, right? That'd be prone. You should worry about a person being prone and being handcuffed because it might cause problems with breathing, right? It might, because of the position they are in, lead to them not being able to breathe, which has a medical term called asphyxia. You may have heard of this recently, so you have to look at the whole picture. Eighth Circuit Court of Appeals, in your qualified immunity decision. Such evidence, when considered alongside duration of the restraint and the fact, says the Supreme Court, please take note that Gilbert was handcuffed and shackled, may be pertinent to the relationship to the need of force and the amount of force, the security problem, and the threat, both to Gilbert and others reasonably could perceive. Having failed to analyze this evidence or characterizing it as insignificant, being handcuffed behind the back and in leg shackles may be relevant when determining the amount of force and restraint used in the qualified immunity decision. The court's opinion could be read to treat Gilbert's ongoing resistance as controlling as a matter of law. Yes, so merely the fact that Gilbert was not compliant, assuming that's true, incidentally, because we don't know, because this has been done on a summary judgment case. So the mere fact Gilbert is not compliant doesn't necessarily mean everything the officers did is okay, or constitutional, or protected by qualified immunity. Such a per se rule would contravene careful, context-specific analysis required by this court. We express no view as to whether the officers did unconstitutionally use force because, again, this is a summary judgment, right? So the facts are being assumed and we don't know what they are yet, and so we're certainly not going to express an opinion right now. Or if they did, whether the right to be free from that circumstances was clearly established. We instead grant petition for cert, vacate, and remand in a summary way. No oral argument, just give it an go. Give the court an opportunity to employ an inquiry that clearly attends to the facts and circumstances in answering these questions on the first instance. So, what can we deduce from this? What can we read from tea leaves in this situation? Well, I think what we can read from the tea leaves in this particular situation is that this is a follow-on, at least in spirit or in subject matter, to other recent decisions from the Supreme Court that have been reversing qualified immunity, which is not really a thing that happened really before, like just now. We covered on our channel that Fifth Circuit case dealing with the Texas prisons and the horrible, horrible conditions they were in. And the Supreme Court saying, no. Right, summary reverse that qualified immunity. Now, give it another try. And now the Eighth Circuit has done something with the summary judgment, giving the officers qualified immunity, and the court's saying, you need to look at this with a little bit more factual care. You need to make sure that you're not just simply saying, prone position A-OK, because he's resisting. Other factors may be relevant. And also relevant would be the training materials and so forth and so on that you may not have fully considered. So I think what is being said, or at least what is being signaled, or what I hope is being signaled maybe, is the Supreme Court is indicating its increasing appetite to reconsider some of the underlying principles of qualified immunity. The Supreme Court is hinting and teeing up that, maybe this qualified immunity thing we've been doing for a while now isn't all it's cracked up to be. That's what I keep saying. I keep saying, let's make Skidmore great again. Skidmore was great. It was wonderful. We just looked at the objectively reasonable officer and what an objectively reasonable officer would do. It was wonderful. The reasonable man test. Let's make Skidmore great again. Instead, what we did is we adopted this whole qualified immunity thing where we said, unless your rights are clearly established, and we know all too well what clearly established really means as a matter of practical reality. So we can look at this and probably conclude the Eighth Circuit didn't come to the wrong legal conclusion in the end, as sad as that is, because we know how clearly established needs to be. But the Supreme Court is saying, why don't you give it another go? Not necessarily because you screwed up the legal conclusion, but more to the point, they are signaling, or at least this is how I'm interpreting it, right? They're signaling to the wide world, maybe we need to reconsider that qualified immunity thing, give that another look-see. And we're going to put out these feelers as sort of a way to see if we can find a case. This is probably not it, incidentally. If we can find a case that will allow us to reconsider this doctrine and perhaps let's make Skidmore great again. So, yeah, I think that's probably what's happening. So the Supreme Court has told the Eighth Circuit to take another crack at it, develop the factual record, regardless of whatever legal conclusion is. They will do that. They'll probably still affirm qualified immunity, to be quite honest. The Supreme Court probably won't take cert on it, if I had to guess. But maybe that's not the point. Maybe the point is the Supreme Court just indicating, hey, we're, between this case and the Fifth Circuit case dealing with the prisons, and the other Fifth Circuit case, which I can't remember what that dealt with right now, because there was 2 Fifth Circuit cases that were reversed this way. So it's like the third one, I think, this year. So maybe the Supreme Court is trying to tell us something. Like maybe qualified immunity needs to be given in our look-see. So I thought it was interesting, and I also thought it was done interesting that it was done in this summary way and just done in a way that this, you mean, like whatever. So, yeah. So we'll see what's going to happen. So we'll see if the 8th Circuit, when they take another look at it, if they can figure out something, and we'll see what legal decision they come to and all the rest of it. But that's all for now. If you're enjoying this, please remember to give it a like. If you haven't hit the notification bell, it seems to help. Hit the all for notifications. It's got to do something, right? One would think. And tell your friends so that we can do more uncivil law stuff. I hope you've been enjoying this morning live stream. Until later, my friends, I hope all is well. Cheers and goodbye.